Yes, welcome to the No Stay Project live from the fortified compound here in Mesa, Arizona. Glad to be with you here. Another glorious day in the Valley of the Sun. And it is December 4th, 2019. And let's get right to it. Always got to thank those who support the show. Appreciate it, Chris and Eyal and Nelson and Mark and Don. Bill, of course, Dan, New Hampshire. Appreciate that. If you'd like to help support the big show, you may do that at two. I did it. You see. I don't think I'm having a tech issue, but I'm having a brain fart. All right. It is markstevens.net and markstevens.cells.com. And if you are being attacked by a bureaucrat there, or somebody has hauled you into court on a bogus charge, you want to learn how to more effectively defend yourself, you can go to markstevens.net. You can get a copy of Government Indicted, which has a whole model, as well as just the show archives. All the No Stay Project shows are archived there, as well as being here on my YouTube channel. And I guess maybe until YouTube determines it's not financially viable, but I was a little concerned with that, but it doesn't seem like that was going to affect that they were going to just start deleting channels that weren't monetized because it wasn't, economically viable. So what we do here at the No Stay Project, for those who are new to the big show, is going and looking at things in court, for example, from an anarchist or a skeptic perspective, and not accepting things as true unless they're proven, especially when someone's making an accusation against you. So the idea is to not take any sacred cows. What we're going to do is we're going to actually hold the prosecution to their burden of proof. That basic logic teaches us, and yes, this applies even in court. And even those who say it doesn't, I would just forge ahead anyway, because we do know that when you're charged criminally, the burden is obviously on the prosecution. So it's kind of, I think it's kind of silly to even trying to make an argument that basic principles of logic don't apply. You're in the fight for your life sometimes. These people want to change the course of our lives. They want to damage us severely. And if you're going to go in with the mindset, well, basic principles of logic, you absolutely can and should hold the accuser to their burden of proof. I mean, all across the spectrum, it's there where you can use fancy Latin phrases like prima facie. There is a certain, that there has to be some facts, that the one making the accusation has to have some minimum facts that, if taken as true, tend to prove the conclusion. So, the burden of proof. We keep the burden of proof on them, and we don't allow for a sacred cow. I mean, how crazy is that? I mean, does anyone really think for a second that it would be considered a rational and an effective way to defend yourself against an accusation if you're actually going to give the accuser a free pass, and then to give them a free pass on the very foundation of their claim against you, that nothing they say has any relevance whatsoever if the foundation is not proven? And you go, well, I'm gonna just give that to you. I'm gonna give it to you. I'm actually gonna aid in my own prosecution here. I'm gonna help you out. I'm not gonna make any waves. I'm not gonna go and challenge the very bedrock, that the foundational claim that you rest on. I'll give you a pass on that. I'll give you a pass. You don't even have to make stupid arguments. Oh, it's philosophical, or it's a fundamental legal question. I'm not even going to go that far. I'm going to give you a free pass, and I'm going to say, you go ahead and you make a foundational claim against me, and I'll deal with the rest of the stuff. I'm not gonna bother that. I mean, why would we bother when we actually have circumstances that we have been reported where prosecutors in and out of court, although I'll give you this, mainly out of court, actually argue, I don't have to prove that. Imagine the accuser making a serious accusation against you, everything hinges on that foundational claim. I don't have to. I don't got to do that. I'm a phone call. I don't have to prove that. And so, if you knew, we're supposed to be getting a fair hearing here. We're supposed to due process requires a fairness, fundamental fairness, which means the rules apply to everybody. And if it's not a big deal to make a foundational legal claim against somebody and then argue, I don't have to prove that, see if you can get the same courtesy extended to you. Mr. Judge over here, are you going to allow me the same courtesy you're giving the prosecution over here? You going to allow me to make foundational legal defense claims against them without any proof? We know that's not it. So you're going to hear all these things. Well, it's just similar to what Greg Ives did with our friend Bill in New Hampshire, where they wanted to say that jurisdiction, the applicability of the law that allegedly creates subject matter and what do you call that there, personal jurisdiction, off the table. Can't discuss it. We can't discuss and what he really meant was we can't discuss a challenge to that. Because if jurisdiction was off the table, then it wasn't a decision that he could make for or against the NHES, New Hampshire Economic Security. But he was more than happy to make a determination in their favor. He just said it was off limits to make a determination that it was not in their favor. Well, that's not saying that the decision is off the table. What that's saying is you can't challenge it. And if you can't challenge the foundational claim, they literally testify to that claim during the hearing. Not allowed to challenge it. I guess some may argue it's a political question. It's philosophy. Well, let's stay with the political one. That came up in an email recently. If it is a political question, then it's not up for decision. They can't make a decision for or against. They can't make a decision on jurisdiction or the applicability of the code, period. Which means they cannot confirm the NHES's decision. But that's what they do. If it truly is a political question that cannot be addressed, then you can't answer it in the positive or the negative. You can't address the question, period. And if you can't address the question, you can't make a determination that there's jurisdiction. You can't make a valid determination that the laws apply and you violated them because it's off the table. You can't determine that they were violated if they apply is off the table. See, logical consistency, fairness, due process. But when it comes to this hot button issue, all bets are off. I even used the word hamstrung. I said, well, if you're going to go and determine, Mr. Ives, if you're going to determine that the applicability of the code jurisdiction, if you're going to say that is off the table, then you're hamstringing it. There's no point in having a hearing because they can't prove an obligation was created because you can't discuss what actually creates the alleged obligation. So, yeah, I know, Bill. That's what I was talking about. I had seen that. We're going to rehash the exact same thing. I guess if I have the time, and I'll do what I can to make the time. Yeah, we'll actually set aside some time to have Juan Galt. We can have a discussion on jurisdiction and prima facie evidence. Because even when I read what prima facie evidence is directly from Wikipedia, I'm still accused of, not that Juan Galt did, but I'm still accused of getting it wrong. I can read direct. It reminds me of Brian Strong. I read directly. All I did was read directly from Brown versus Texas. And he just snaps at me. It's your interpretation. Well, no, that wasn't commentary. That was a direct quote. So even when I quote things directly, I'm still wrong. So, all right. So don't let anyone tell you can't and shouldn't keep the burden of proof on the accuser in or out of court. Like they try to pull this crap. Well, once we decide that there's jurisdiction, it's up to you to prove that we don't. No, not unless there's no shifting of the burden, unless you have actual evidence. And if you just say we have jurisdiction because we said so, that's not evidence. And if you consider that evidence, then fairness dictates you got to accept it from me also. Something's true just because I said it. And we all know that's not going to go anywhere, nor should it. Nor should it. Things are not true just because you say it's true. You think that wouldn't have to be repeated, but apparently it does. Let me take a look here. We got callers lining up. Okay, so I'll wait on my Skype calls, but we've got some new callers. I'm going to put the headphones on here. And let's see what we got over here. We got area code 313. You're live on the No State Project. What's your name? Where you calling from?
How you doing today, Mark?
I'm doing great, but you got to turn the feed down behind you.
Yep, I got you.
All right, what's your name?
The other week about it was going to court.
You're calling about going to court. Okay, we can help with that. What was your name? Where you calling from?
Michael from Michigan.
Michael from Michigan. Anywhere near Detroit?
Inkster, yes, right outside.
All right. Well, what can I do for you today?
I talked to we talked about the last time when the judge told me the Constitution, she represented the Constitution. And I went back today.
Okay.
She didn't try to push the lawyer on me as like they said, but she set it for a trial. They're gonna mail me that information in the mail, so I don't know when the trial will be. But she said she denied the motions again. She said she denied them. Ultimately, the reason that they were denying the motions is because they didn't state no Michigan court rules in them.
Well, so Michigan laws are, or Michigan court citations are in there. That's not, so it's not true. It was crossed over and there are Michigan cases in there. And
right.
And even when there's not a Michigan Supreme Court citation, there is an equally applicable United States Supreme Court decision. So, for example, that the what is necessary to have a legitimate case or controversy in an adversary proceeding is not a Michigan Supreme Court case, but there is a United States Supreme Court case saying that this is what, because it's all yes, the Michigan state system is not the same as the federal system, but it is still it's still an adversary system. So I'm not saying that every single Supreme Court case is going to be applicable to the situation and an argument that we're raising in a Michigan state court. I get that. So when I do use a Supreme Court case, I make sure that it's applicable for that argument. So they're dead wrong there.
Well, she did kind of admit that she was going by the fact that she believed that jurisdiction was proven, but they never told me what it was that was proving this. And when I asked her, she said, before talking about the trial, I asked her, well, how can we even go to trial if jurisdiction hadn't been proven yet? She said, well, she proved it. She told me about the police officer said I did this, that, and the other, and those were the facts. I told her, those are facts, those are opinions and allegations. And she said, basically, as far as I say, so I say.
I would throw this out if you're able to get this in there again, where she says she believes that jurisdiction's been proven. We could say, well, is that because you say so or because the prosecution's evidence does? And if she does say the prosecution's evidence, then you can ask, well, what specifically proves that just because I'm physically in Michigan, that a written instrument called the Constitution applies? The only thing she could do is just repeat that you're here, but that's not actually proving that the claim is true.
So if it was to go to a trial, I would have to basically convince the jury that what I'm basically saying that they don't have evidence proving jurisdiction.
Well, it can't just because you're saying it. It's gonna count more in our favor if the prosecutor and the judge say it. So that's why in the cross-examination, when we asked a police officer, did you determine on your own that just because you saw me physically in Michigan, that the laws applied and gave you jurisdiction to investigate and charge me? And then you ask him what facts did he rely on to support that legal decision that he made, that legal claim, that legal that legal determination. And that's when his lawyers will object and say objection call. We've covered this so many times on the show. Objection calls for legal conclusion. The witness is not competent to testify. And you just have to point out and maybe move for sanctions against the lawyer, the prosecutor, because you didn't ask a question that required a legal conclusion. You asked him for the facts that he relied on at the stop, going back to the prior testimony, the prior statement that he made. The jury needs to see that they are impeaching their own witness. Now, I've got a critic that says, you got to tell them about Rule 701 and Rule 702 that allows them to give opinion testimony. The problem,
right.
The problem with that is the objection is completely off point because they're lying and misrepresenting the question because you didn't ask for a legal conclusion to be drawn. 2, if the judge has it in his head and they're convinced that you are asking for a legal conclusion to be provided, according to the same critic, only judges can give legal conclusions. So why 702 would allow a police officer to give a legal conclusion, which only judges can make, but let's just say for sake of argument, they're going to allow. You're not asking for an opinion. So using 701 to 702 has nothing to do with the situation. But, just that you could throw it out there and say, but I heard on the internet, use 702. 701 and 702, they allow the police officer to give opinion testimony, even though you're not asking for an opinion. Throw it out there. I would love to have somebody do that just as an afterthought so that you can come back and report on what happened. And if you had to appeal, use that argument in the appeal. And then depending on what happens, when they completely shut it down and say, this is ridiculous, you can come back and I can post it for everyone to see that arguing for opinion testimony from the cop is not relevant to the situation because you're not asking for an opinion.
Also, I asked her, I said, how can I get I asked her once again, how can I get the transcript to all these proceedings? And then again, she said, I'm going to mail you a card. I'm going to mail the card to you and let you know that information. But basically, she said, well, Mary, you're going to have to pay for it. I'm like, no problem. I'll pay for it. But how do I get it?
Yeah. Well, the clerk, you should be able to get that to the clerk. You don't even have to go through the. You should. You shouldn't necessarily have to go through the judge. That's something that you just go to the clerk and you get. The judge shouldn't be involved with the transcript at all because they're the subject. They're one of the subjects of that.
Right.
So I can't believe I'm still going to try to get to one of Trump's bankers killing themselves, but. I'm going to have to move on quick. I could take one more question because I got a full line of calls. Wow. Good guys.
Oh, I just thanks for accepting my call. You said just stick with the motions and keep asking the questions.
Yeah, listen to this call again. What we were talking about before. Don't let them off the hook. Ask leading questions. Don't ask the judge an open-ended question. You have to have the information in the question so that you can limit or lead to a certain yes or no answer from the judge, so that you can keep things focused. So so when you're asking why they're denying the motion, don't just leave it like that. Ask them, why did you deny the motion? Are you satisfied that the prosecution has met their factual burden? That's a much better question than to just leave it open so they can give you a narrative.
Okay. I'm going to try that. Thanks for accepting my call. I'll call you back and let you know how it works. Everything works out.
I appreciate the call. Thank you, Mike. Oh, man, we are hot tonight. A lot of calls. I'm gonna do my best to get to everybody here. All right, I think this is Washington. Yeah. We've got Rock in Washington. Welcome back to the show.
Hey, Mark. Great to have you on the line here with me. We got truncated the last time the call got dropped when we were talking, and I never really got to the issue I wanted to talk about.
Oh, that sucks.
How are you today?
I'm doing all right. I'm doing all right.
Good. Well, the reason I'm calling, I had sent you an email and hadn't gotten a response about it. I got a speeding ticket, a photograph speeding ticket in Sherwood, Oregon, from the Sherwood Police Department, and I was not physically in the state of Oregon at that time. Have you ever heard of that?
Oh, yeah. Yeah, that they want you to rat out. I like, especially, at least in California and Arizona, they wanted you to rat out who was actually in the car.
Right. So I called the officer. There's one sergeant at the police department that handles these things. And I just said to him, matter of factly, I said, well, first of all, what evidence do you have that I was in the state of Oregon? Well, your car was there. We have your license plate and blah, blah, blah. And I said, well, I was not in the state of Oregon at that time. So your fallacious, prosecution of me in this event, well, all you have to do is, you get your copy of your license and do an affidavit and blah, blah, blah. He starts in with that. And I said, well, unfortunately, my rate is $250 an hour. So if you want me to start putting dossiers together to prove my innocence when the burden of proof is on you, I don't know how you can try and prosecute me, because I wasn't even in the state of Oregon at the time of this alleged offense. And he goes, well, you can charge us whatever you want, but we're not going to pay it.
Sure.
And, so finally he said, all right, we just sign the paper and send it back in. I should have charged him the 55 cents for the stamp too. And I was reluctant to do it, but I felt, if I don't do anything, then this thing is just going to fester and it's going to get worse. But they did send me a sign off on it that, that they've dismissed the case from just signing the paper that they sent originally, declaring that I was not the driver of the vehicle. But to me, this whole thing is ass backward. I mean, why do I have to prove my innocence? The burden of proof is on the prosecution.
Yeah, but here they probably don't even consider it that it's a. You got a lot of background noise. It's probably not considered criminal when he's photo radar. It's being treated as civil, so they're looking at the burden as the burden even in civil is 100% on the plaintiff. That never changes. Jurisdiction's always on the plaintiff. But here they may be looking at as far as a preponderance of the evidence, and they're going to look at the record and say, well, it appears that you were here. If you have counter evidence, then that's something you could present at trial.
Mm-hmm.
So the judge could consider that.
I had been driving the vehicle, and then I had received a summons that way. I guess we would have just gone right into your your, I don't even know what the word I'm looking for, but the way you handle these kinds of cases, and just said, well, what jurisdiction do you what proof do you have that your jurisdiction applies to me just because I was physically in the state of Oregon?
Yeah, and just for those who are new, we don't put it that way. We first said, well, you're operating under the assumption or the presumption that just because I'm physically in Oregon, that your laws apply and give you jurisdiction to do X, Y, Z. And then when we confirm that, then we ask them for the facts, and works out a bit better, because it's not then we're not making an affirmative statement. And if we are going to make an affirmative statement, it should be based on the facts, their own testimony, that they confirm that that's how they're operating, and they have no idea, or they admit that it's an assumption. And that's a bit stronger. We don't want to make affirmative statements unless it's based on the facts and that their testimony. So if you listen to the Call of Shames, I always go back to their, well, what facts do you have that I'm wrong? I don't know. I asked you what facts you relied on to support your claim, and you said I have no idea. So those are my facts. Right.
Yeah, your IRS calls are brilliant. And you were brought to my attention by Brian Young over at highimpactflix.com.
Cool.
And I think you referred to him as highimpactfilms.com, but it's actually FLIX, Flix. And he's on Twitter and YouTube as High Impact Flix, HIGH Impact Flix, FLIX. But he's a big proponent of yours. He turned me on to you and many of his other followers. He's got 500,000 people, I think, on YouTube. And that's even after they trashed his channels. And it's crazy what they're doing to people. He never incites anything. He's a peaceful person. He never makes any crazy statements. He never uses vulgarity. And they're still sanctioning him and censoring him. It's nuts.
If you get a big enough channel, and if there's any chance that you could have some meaningful impact on social change, then you're going to come under fire. If you are challenging the status quo and having people go in and actually embarrass these politicians just by asking a few questions, so one of the, hey, if I was to do things the way you guys do, the government there, if I did the same thing and I forced everybody in my neighborhood to give me money, would you consider me a criminal? Of course, everybody. Well, yeah, of course you're a criminal. People understand basic principles of right and wrong and basic ethics. They get that. It's just they are, there's too many people operating under this cloud that there are a small group of people in the world that the rules don't apply to, and that they not only that, they have a moral right to be immoral. They actually believe that, and when you go against that and you start breaking that down and not necessarily telling people what to think, but more in how to question and think for themselves, and they start looking like, hey, you really are just a group of men and women forcing people to give us money. No wonder you're so corrupt. No wonder there's so much violence. Violent domination, no accountability. Gee, what do you think is going to happen when you do that?
Yeah. Brian, I think High Impact Vlogs, he had to start another one, VLOGS, because they sanctioned his first YouTube channel. He had a First Amendment audit video on there, a guy from Rhode Island, and he was just being manhandled by the police, by a female police officer. And she said, no, you're going to identify yourself. He's like, no, I'm standing on a public sidewalk, filming a public building, standing in a public space, filming what I can see in public. That's completely, that's suspicious activity. And he said, well, it's suspicious. Is that a felony or is that a misdemeanor? Oh, well, you're suspicious. So until I find out who you are. And then the chief of police says, oh, she acted appropriately. If he had just identified himself, he could have gone on his way. So it's the Nazi Germany, version of you just do what we say and everything will be fine.
Yeah, you blame the victim. Hey, she shouldn't have wore a dress that she should not have been dressing provocative. Obviously, she was looking for trouble. I mean,
Yeah.
it's blaming the victim. Just like when the IRS attacks. If you just did what they said. Yeah, Philando Castillo was just doing as he was ordered to do, and he still wound up being shot. There are videos of people who are complying to the letter with cops screaming at them, and they're still killed. So, no. Well, I appreciate what Brian has done. I wrote down. I got the name wrong. I do sincerely apologize to that. I would here for this situation. I just filed a motion to dismiss as usual with the discovery request. You don't include a Brady request, or at least don't call it Brady. And you typically, you're not going to get pretrial discovery. You're going to get it immediately before the trial, but I would still ask for it and take it. That's the way I would do it. With the photo radar in Arizona, I'm 100%. I have gotten every single one of those tossed out. I've even gotten some tossed out in California. Though I don't, I'm not 100% in California, but I've got a lot of them tossed out. Photo radar ones are usually pretty easy. You could even put in there that you could put in there that there's no evidence it's actually you.
Right. Pursuant to that, and this could help other listeners today as well. Does Mark Stevens Selz, SELZ, correct? You have information about how to go about this stuff there? Can we buy a little PDF file or something? Is that how it operates?
Yeah, you can get it off my website. One of two ways. You can go use Selz, go directly from, I have the buttons on my website for Selz. It's markstevens.selz.com, and markstevens.net is my website. If you don't want to use Selz, you can use PayPal. So both options are there. So you can get the book, you can get the scripts, you can get consultation, get that set up. You can do all that stuff.
I'm going to buy that stuff. And do I have your permission? Can I give that to my friends and family, or copyright wise, or do I need to send them there to get it?
You can send them there to get it, but I'm not a copyright kind of guy. So look,
I understand.
People are going to take it. The ultimate thing is that people are able to defend themselves more effectively, and it helps people. So, if you appreciate them,
karmically, you're going to be a huge benefactor of anybody utilizing that. I'm a real fan. I'm very, very appreciative and humbled that you took my call today, and thank you so much for what you do.
Oh, I appreciate the words, but I'm just the guy on the phone here. So I appreciate that. It's just a matter of the more people we've got out there questioning it, the more difficult it's going to be for them to maintain a facade of legitimacy. And maybe that's a bit of a push to getting us towards a voluntary or governmentless society, or at least a government as we know it, the violent institution that it is that we know today.
Yeah, I mean, I'm looking at a headline on MSN on my computer. I'm staring at the screen right now. William Barr, : communities that don't show law enforcement more respect may lose police protection. I'm thinking, this is a bad thing? You can take my police department?
Yeah. Well, we're just going to take our guns and go home. All right. Okay. All right, well, I'm going to try to get to some more calls there, Rock, but I appreciate the call. And let me know what happens with that case. Is this going to be a regular thing with Rock? Okay, well, appreciate the call, Rock in Washington, fighting a photo radar ticket in Oregon there. And not too many new callers today, but we've got Ronnie from Illinois. Welcome back to the show.
Hi, how's it going, Mark?
It's going well. How you doing?
Pretty good. I just want to say I appreciate what you do, man. You've already helped me out quite a lot. I've had 20 charges dismissed, and I mean, you probably saved me $4,000 already.
You've had what? How? Say again?
20 charges dismissed.
You know, as appreciative and glad as I am to hear that, man, I've got to ask you, what the hell are you doing to get 20 tickets? Jeez.
I was on the free man on the land stuff.
Ooh.
I didn't have my license for a while, and then 2 years, and I was doing a whole bunch of other stuff, and you know how it goes.
Well, and what broke you with of that whole ideology?
Well, I was going through your method and a couple other methods, and I was mixing them.
Oh,
and yeah,
Ronnie, never like to hear that. I'm glad you got things tossed out, though.
Yeah, but there's still one they're not dropping though. It's
okay.
Trespassing for on state-supported land.
Ooh,
and that's the charge. Yeah, something like. And then, well, so I filed the motion to dismiss, like you say. It got dismissed without any grounds, and I ended up getting kicked out that day. And then, basically, these judges don't want to deal with me, so they have the prosecutor deal with me. So I basically had like 3 pre-trials before I filed the motion to dismiss for prosecutorial misconduct, like you say.
Nice.
And then that one got dismissed without merits. And then I just had another quote unquote, supposed to be arraignment today, but same thing happened. The judge didn't want to deal with me, so it was, I guess, quote unquote, another pretrial. And I actually ended up bringing up the charges, and I was like, so what does that even mean? You know, like, what does state-supported property mean? And I'm going through it, and he ended up saying something about the building, you know, and the evidence that he provided in the discovery shows me outside the building when I got arrested, you know, and as soon as I was grilling him on that, and as soon as I did that, the judge saved him and, you know, started threatening me and
whoa,
whole nine.
He started threatening you? What, he's gonna, with contempt?
Yeah, he's like, I can hold you in contempt for 6 months, something like that. I'm like, Jesus.
Okay, so you're proving that you're a bully, but what's the, you know, were you speaking over anybody? Were you being aggressive? Were you?
Well, he didn't, like, I'm loud, and, you know, that's how I normally talk, you know, and I guess I don't know. I was just talking normal, and he's like, stop raising your voice. And I was talking normal, and I'm like, well, I'm not raising my voice. He's like, you just raised your voice. What are you talking about, dude? No, I didn't.
Yeah, it's like the whole thing, dude, calm down. It's like, if you want to really annoy somebody when they're not, yeah, okay, keep telling them to calm down. It has the, you know, if your intent is to piss somebody off, take a calm, rational person and just start saying, dude, calm down. Just dial it down a bit. What are you, dude, calm down. Yeah, that's one of those stupid lawyer tricks. Just calm down. I had it pulled on me.
And it's the gaslighting. It's the gaslighting too.
Well, what are they trying to make you feel like you're? Are they trying to make you feel like you're crazy because you're questioning their claims?
Well, I maybe, but yeah, I mean, they have it. All they have is their opinions. You know, I ask them for the evidence. They only have opinions every time.
How are they trying
to have anything else but opinions?
But how are they trying to gaslight you? You know, maybe you're not using the word right.
No, I was saying like with the tone of my voice, or like with the volume of my voice. You know, try to make it seem like I'm doing something I'm really not. You know. Okay,
I get that. So when you are doing these pre-trials, are you hammering away at their foundational claim? Okay, so what evidence?
Yeah, and all they provide is, they don't provide anything. All the prosecution says is, we have jurisdiction, and you subject yourself to the law. And then he said that by filing motions in the court, you subject yourself to there, and he just all crazy stuff.
You know,
It's word for word what you say is exactly what they say every single time. You know, it's just getting over the threat. Really, is what it is.
You know, I would, if you were able to record what that prosecutor was saying, it would be awesome.
I did.
To be able to then use. Okay, well, follow me here. You have the prosecution in court on record saying the reason why the court has jurisdiction over you is because you're there and you filed a motion. Now, imagine going and suing him for the damages that he's causing you. And imagine putting into that complaint his very words. So knowing that they're going to file a motion to dismiss, challenging the court's jurisdiction because they have absolute immunity and say, no, you said right here, filing a motion gives jurisdiction. The moment you filed your Rule 12B motion, you gave the court jurisdiction according to your own statements. Yeah.
Yeah, they didn't know I was recording them though. So.
You can't use that then. Well, unless it's a one state. You know, I don't remember if Illinois is a one state recording or not. Well, then again, it was in court, so you could be held in contempt. So. We're not going to you're not going to let them know.
I'd rather have it on record. I'd rather have my own record of it anyway, you know, because I mean, I'm already. Oh yeah, and that's the other thing I was going to say. You know, I'm already going there alone, and then during him saving the prosecutor, like on my way out, I was asking, you know, because they basically just kicked me out, and I was like, well, am I going to get a new court date or whatever? And he's like, I'm gonna. I'm going to failure to appear you while I was standing in front of him. Like, what are you talking? Like, really?
Man, a page right out of Peer Pan from Scottsdale to, you talk about a real, if you can get a recording of that, the court recording, if there is one, that is, I mean, here the whole thing with impeaching Trump was the abuse of the office. When you've got a judge who is going to failure to appear you and you're standing in the court, that I'm going to go on a limb here and say that's some hardcore abuse of office. I mean, I already mentioned bullying. I mean, that's just criminal. Wow. Wow.
Well, and it's a small town, you know, like in these big cities, these judges are all prepared for masses of people to come through, you know. It's literally like a feeding frenzy, dude. Like I saw 100 people in there and four prosecutors just eating them up, you know, just taking bites one, you know. They were just like tag teaming them.
Well, yeah,
it's crazy. I was literally the only one who talked to that judge the whole time. All he has to do is sit there and sign his name. And how much do they make?
Yeah, it's a money making machine. Have you asked the prosecutor which witness he relies on with personal knowledge that the Constitution applies just because you're physically in Illinois? Have you asked him that directly? That's an appropriate question for pretrial.
I don't remember if I asked him that directly, but he always says that. Challenging jurisdiction is a trial issue, and then I immediately go to, I immediately go to, isn't, you know, the Supreme Court's ruled multiple times that jurisdiction can be challenged at any time, you know. They don't like that, obviously.
Yeah, well, it's better to say, objection, are you actually forcing me to go to trial absent evidence of jurisdiction? We have a judge in Ohio who actually said yes. Because the judge there has to be evidence. The prosecution has to satisfy the judge and for due process that to even have an arraignment and a pretrial and to set it for trial, there has to be evidence of jurisdiction. Again, imagine suing them
all the time.
Yeah, I know, but imagine suing them and ramming those words right down the judge's lawyer's throat. No, your client is the reason why we're here today is because your client, the judge, lied and said jurisdiction can't be challenged. It's a trial issue only. Was he telling the truth? Yes or no? See, the problem for us is because judges have absolute immunity, that's not a way to go about holding them accountable. But I think it would be great. It would be a good use of money to actually get the judges a record of the judge saying that, and then use it against him. I mean, we had the opportunity in New Hampshire, but Derek J wound up moving, and so he wasn't able to follow up on that one. But here, maybe you can.
Well, you expect me to do that after being threatened with contempt for 6 months? You know, that means I'm not getting out till July to deal with this matter again.
No, Ryan, what I'm saying is if you can get a recording of it after this is over, then you file an action against the judge and prosecutor. And then you use their lies against them so that you can get it in the record. Okay. And then I would then use that to then file an insurance claim and go that way, because at least then you don't have a sovereign immunity issue. Yeah, I'm not saying to do it now.
Well, yeah, I'm actually in the middle of doing that, because in this same charge, while getting arrested, I got jumped by 6 cops. So yeah, they don't like it too much.
Yeah, that's definitely not good. So yeah, if you were jumped by 6 cops, hopefully you weren't hurt too bad. But then yeah, you definitely got grounds for a claim for damages.
Well, I guess the reason why I called you is so after the motion to dismiss, it goes the motion to eliminate, then the motion to recuse, then a motion of or interlocutory appeal.
Well,
and where does it go from there?
If the judge denies the motion to dismiss and gives you no explanation, and he bullies you, and he's lying and saying that when you're challenging jurisdiction, he's lying and saying it's a trial issue. He means it's a trial issue only. What?
That was the prosecutor.
Oh, the prosecutor said it was a trial issue?
Yeah.
Oh. Well, if the judge is not holding the prosecution to their burden of proof, and he's bullying you and threatening you, then I would file I would file a motion to recuse the judge based on that. He is not fair. You can't get a fair trial because the guy is threatening you. He's threatening you and falsely. Falsely accusing you of something that you're not raising your voice. If anything, the judge probably was. You wait at least 21 days. You wait at least 21 days regarding the discovery, and if you don't get the discovery and they continue to press forward, arguing without supporting facts, then you file the motion in limine and the motion to dismiss for prosecutorial misconduct. Now,
I already filed the motion.
You filed which motion?
I already filed the motion for prosecutorial misconduct.
Okay. Now, if the judge
and I've already received their so-called discovery, whatever.
Well, I doubt
and whatever else.
I doubt they're being honest and saying that their witness lacks personal knowledge. That's discoverable material. It goes to the impeachment of the witness. I doubt he's actually spelling out my witness lacks personal knowledge. So you got a Brady violation right there. When you mention the interlocutory, that has to do with if you file now the motion to disqualify the judge, and you lay out your grounds, and you have to have facts to show that the bias is so strong, and it's not from it's from an extrajudicial source, that his bias is so strong against you that a fair trial isn't possible. Obviously, bullying you is evidence of that. If he denies
interlocutory appeal and
I'm getting to that.
Motion to recuse are the same thing.
No, they're not. If he denies the motion to recuse, then you use an interlocutory appeal, or it's called a petition for writ of mandamus. That is the legal remedy to review the denial of the motion to recuse. And that is filed in the higher court, and you always do it with a request for a stay of proceedings. So you want all the proceedings in the trial court stayed pending a final determination of the petition for writ of mandamus.
Well, what's the point of filing a motion to recuse if they're just going to put another judge on there who's going to do the same thing?
Well, because not every I use an example with me in the Mesa City Court. I had done a recusal and got the judge recused, and I actually pulled Judge Ortiz, who at the time was like the only one that you had any chance of sticking to the rules. He could just despise you, but he somewhat stuck to the rules. And because of that, I showed up for trial thinking, hey, this is, I stand a chance here. And so Craig Jones walked up. He didn't even stop at the desk. He just walked into the court, handed Judge Ortiz, I think it was Ortiz, handed Judge Ortiz the motion to disqualify. And he says, Mark, I understand that you're objecting and this is frustrating. It's literally, the day of trial. There's nothing I can do. The rules are the rules. So I do it because there's still a chance that the next judge is not going to blatantly bully you and carry the prosecution's load. That's why.
There's always a chance.
Look, not every judge is an irredeemable prick. That's why
I mean, come on, Mark. I mean, you had more experience than me. I mean, most of them are.
We have a lot of stuff thrown out. Even when they're pricks, that doesn't mean we don't get things tossed out. Because remember, the prosecutors tend to be just as vile a group of people as judges. I mean, judges are former prosecutors.
Yeah, but they can't throw you in a cage.
Well, right, but what I'm saying is prosecutors don't always rub the judges the right way either. And the judge may have an axe to grind, may not like the prosecutor, may think the prosecutor's arrogant. Yeah. Maybe that the prosecutor's so arrogant. He says, I'm not going to, look, some judges, I'm sure I am not going to sit here and bend over backwards for the prosecution just because I used to work in that office. Some of them actually take their job serious. And the reason, the thing is, we're able to get a lot of things tossed out. You can just, you've had a bunch of things tossed out. We still have things tossed out because I think most of them, even if they're scumbags or come off as arrogant pricks, most of them still want some appearance of due process. And that's why it's the only reason why we can get these things tossed out. If they were all irredeemable scumbags, I wouldn't be doing this trying to help people in court. I'd be railing against the system. I'd be presenting proof that it should be abolished, but I wouldn't be helping people get things tossed out of court if there was no chance. When just bear with me for a second. When it comes to my attention that the circumstances are like they are with the California Franchise Tax Board, when there is no remedy, I publicly say I cannot help you anymore. I've gone on record for the last few years.
Yeah, you said that.
So when it comes to, if it gets to a point where there is no remedy, I will not be helping people in court because you had no remedy. Again, we have other things that we would be doing activist wise, but I certainly wouldn't be helping people. I couldn't get on this show or any show and say, hey, more effectively defend yourself. No, because you had no defense. So we're not at that point.
They sure do.
This isn't North Korea yet.
They take their extortion seriously.
Yeah. Well, I'm going to try to get to another call before we're totally out of time. Oh man.
All right, man. Yeah, I appreciate everything you do, man.
Well, keep in touch, and if you need a template, a good template for the motion to change the judge, just email me, and I'll get that to you after the show.
Yeah, I plan on getting a consult with you anyway. So
excellent. All right, I look forward to it. I appreciate the call, Ronnie.
Sounds good. Sounds good.
Right. Ronnie in Illinois. Oh, we're going to run out of some time over here. I'm sorry about this, but we'll do our best. We'll see how long. We got Stephen from Kentucky. Welcome back to the show. What do you got for us today?
Hey, I had court the other day.
Good news?
I finally got discovery after 5.5 months.
Oh, so that's good news.
Yeah, and of course she's objecting to a bunch of stuff, saying, "Oh, this is just overly broad," and of course I bring up the jurisdiction issue, and she's like, "Well, the previous judge denied that," and I'm like, Yeah, she gave a bunch of legal conclusions. I'm raising issues of fact. I'm not raising any issues of law. I mean, what facts do you have? And then, of course, the judge, I mean, the biggest thing that I have an issue with is the prosecutor literally left the courtroom, and then I asked about the motion in limine, which I filed. And she said, well, I had reserved the right for the prosecutor to object to it. And I'm like, well, she's not here to object to it. The judge pulls out her cell phone and calls the prosecutor back in. The prosecutor comes back in and she says, well, I'm more inclined to agree with you. And this is the judge talking. And then when I'm sitting there objecting to all of this, they're saying, listen, we're not going to argue with you, as if the judge is literally, practicing law from the bench. I don't know what else I can do. Like it's in the record that my Brady and discovery request with the certificate of service of July 15th is also in the record that her response was given on December 1st. I bring up that this is well past the legal limit. And she's like, oh, well, I thought you had agreed to this. And I said, objection, there is no evidence on the record to reflect that. What proof do you have of that? And that's when I got we're not here to argue with you about that.
I love when they pull out when you're standing in court and they say they're not going to argue. That's literally the most appropriate place for an argument is in court. Wow. The whole thing is governed by arguments other than let's say, a cross-examination. Oy vey, these people. Well, one of the things I would have asked this prosecutor is the denial of the motion somehow does that somehow legally excuse you from your discovery burdens?
Well, they didn't even read the motion, and you know how I know that? Because when I went in on my second appearance on October 21st, which again would have been already past the 14 days that they have, where she's like, well, I didn't receive a discovery motion. Then she's flipping through it in the record, and it's stapled to the motion to dismiss. When I mailed it in, the clerk stapled the whole thing together.
Well, they should be two separate documents.
One thing I know, the judge didn't read the motion to dismiss because they wouldn't have had that stapled together if that was true.
Well, you for future reference, don't staple separate documents together.
I didn't. You could see where my staples they were stapled individually and mailed in.
Oh, they stapled them together. Oh.
I mean, I'm at a point now where I'm not even sure what I can do. This judge, you're literally picking up your cell phone, calling the prosecutor saying, hey, he's raising issues. I need you back in here. If she left, she left. I bet if I left, she wouldn't get on the phone and call me.
No, they'd be on the phone to the sheriff to arrest you.
Yeah.
Nice.
I mean, I'm at the point where I don't even know what to do because every time I try to do it, the prosecutor hasn't even said a thing about the jurisdictional issue. She just says, "Oh, the judge denied that motion. They refused to rule on the motion in limine." I'm just sitting here because she's asking me, "Oh, well, what are you trying to do?" I'm like, I'm trying to make sure the prosecutor doesn't argue for things which she doesn't have evidence for. The judge is like, well, I don't think she would do that. And I'm like, okay, so then you have no problem granting this, correct? And she'll never answer. She'll never say it's anything. I just got the discovery back, and I'll scan and email that to you when I can.
Yeah,
but, I mean,
you can file the motion to dismiss for prosecutorial misconduct, and if you don't have a template of that from me already, I'm happy to send it to you.
Okay, I mean, I motioned it orally, but I guess I can file it. She mentioned because I even got her up there because she had admitted to me that, oh yeah, I was there on your initial court date. They do a night court thing down here, and I'm like, well, this was filed before then. You were the prosecutor there. You were the prosecutor the whole way. And her excuse, the judge is always saying, well, she had just moved to this courtroom at that time, and I'm just sitting here like, objection relevance. I don't know what
nice.
That has to do with anything.
That was good. That's good. I would file the motion to dismiss for prosecutorial misconduct, and I would get with the clerk and I'd get it set for a hearing and so if they set it for a hearing, now the prosecutor has to come in and they have to defend against it. They have to show where they've got the evidence. And it's not sufficient to just say, we're going to present at a trial. They have a discovery obligation. They have to provide this to you. And then you could bring up, you have someone who's going to testify that the laws apply and I violated them, right? Right. Do they have personal knowledge of that? Do they have personal knowledge that the laws apply because I'm physically in Kentucky?
Yeah.
And when they hem and haw, that's called discoverable material. That's Brady information. You have to articulate that. You have to say on the record that your witness doesn't have personal knowledge. You have to disclose that.
And more importantly, then it's like, okay, well, you're knowingly put a witness on the bench that you know is incompetent.
Right. That's that. So we know if it is pushed to trial, that's something that you have to argue. You have to object and say, objection. The witness, there's no proof on the record. We've already gone through discovery. We already have, it's one page. We already know the witness doesn't have personal knowledge. And in fact, if you put him on the stand anyway, I guarantee you, the prosecutor will object to the competency of their own witness within 2 questions that I ask.
I mean, my biggest thing is I don't even should I focus more on just the fact that it took her 5 months to get discovery? I'm amazed that this hasn't been tossed out over that alone. But the judge is just buddies with this prosecutor. Like the fact that you're openly getting on your cell phone and texting her.
Yeah,
how am I supposed to get a fair
bad.
hearing with that? I think that alone is like, it's just ridiculous. I shouldn't even have to put up a defense. You failed to meet your statutory rules, so you have 14 days to comply with discovery.
Yeah, I think
even if we go by the October 21st hearing, you're still well past that.
Yeah, the appropriate thing would have been for the judge to say to a bailiff, get the prosecution, not to pick up the phone and actually call the prosecutor. That's bad. That should not have happened. You could still file a motion to change the judge. And you can point out in there, if the judge wanted the prosecutor back in there, the appropriate thing to do would be to have a disinterested person in the proceedings, like the bailiff, get the prosecutor. To have the judge personally call, yeah, I would say that's not too good.
Yeah, pull out her cell phone, hold it up for everyone to see, and just text this prosecutor. And then if we're already 2.5 hours into the beginning of the morning proceedings, the prosecutor has never shown up, and then she shows up, and
wow,
well, what do you know? That's all of a sudden when I get called, because I'm sitting here thinking, like, is this prosecutor even going to show up?
Yeah, well, I'm gonna
some random person.
I'm going to just leave it at that for right now. The motion to dismiss for prosecutorial misconduct, get it set for hearing, and motion to change the judge.
All right, I'll do that. I almost want to do like a call of shame with this person, because she's just relying on the fact that another judge denied the original demurrer, and she's just refusing to discuss anything.
Well,
just saying that, this is overly broad. This is overly broad. I'm like, without this, you don't have a leg to stand on. What facts do you have? I'm not arguing anything. I'm asking for the evidence your argument is based on.
I love how they could try to get away with overly broad. I'm talking about a specific argument. Your argument that the laws apply because I'm physically in Kentucky. The facts to support that. If you think that's overly broad, you're either stupid and don't understand, or you're lying. And my money's on the prosecutor's just lying, figuring, he's just not a lawyer. He won't know. I can sound really sophisticated, and he
aunt's the judge.
Oh, the judge said it was overly broad?
Judge. No. I have an aunt who's a judge, and I've told her all this, and she thinks this is just beyond ridiculous.
Wow. Well, I would do like I had mentioned and take it from there. I understand the frustration, my friend. I do, but get with me after the show. Email me, and I'll get you the template for the misconduct. Okay.
Yeah, I'll get with you on that, and I'd like to chat a little bit more, and maybe even do a call of shame to this prosecutor if you'd be interested in.
Yeah, I certainly would. I haven't had a call of shame with a prosecutor in a long time, so that's definitely something I would be interested in.
All right. Well, yeah, I'll get at you on Skype, and thanks for everything, bud.
Appreciate the call. Stephen in Kentucky. We're going to try to get one last call. I do have an appointment soon, so I'll do my best to not leave anybody in the queue. We have area code 918. You're live on the No State Project. What's your name? Where you calling from?
Is that me? It would be Linda.
Linda, and where are you from?
Southeastern Oklahoma, unfortunately. Well, originally I am from California.
Oh, well, I don't know. Well, I gotta say, I probably would prefer parts of California like Arrowhead to Oklahoma, but I don't have too much time. So, what do you got for me today?
Yes, sir. I'll try and put this in a nutshell without sounding crazy. I was pulled over on a simple traffic stop. The officer approached the car and said, "We received a call that a black Crown Victoria with Choctaw Indian Nation plates." Already my red flags are going up. That's too much information. And he didn't see me do anything. I worked for a sheriff's department in California in warrants and records department. So I have somewhat of a clue. I don't know anything about, I'm just going down the rabbit hole of we're doing commerce. This is maritime law, all this other stuff. So I'm a babe in the woods with it, but I have a clue of what's going on there.
It's not commerce.
The officer approached. Pardon?
I gotta jump in here. Stay away from this commerce stuff. This whole thing that everything is commerce and they're trying to contract with you. Hell no, absolutely not.
Yes. Thank you.
Yeah.
Okay. Thank you.
Stay away. Okay.
Thank you. All right. So he approached the car, and I did say, I am going to stand on my rights. I will not roll my window down all the way. You didn't see me do this act. I don't think I swerved, but okay. Then they start sharking the car and accosting my passenger for her ID and everything. And I said, "Look, you don't have to give that to them. I'm still not sure what we're doing here. They didn't see me swerve. They must have my car mixed up with someone else, perhaps." Now, unbeknownst to me, yes, this gal did have things going on, but whatever. I'm still sitting here innocent. Never been in trouble in my life, and I'm well over 50 years old. Never been in trouble, ever. In fact, this is my first ticket, and I couldn't wait to sign it so I could sign without prejudice under it. Right, wrong, or indifferent. A little knowledge is dangerous, but that's not half of it. We get the ticket going, and he puts it through the window. I have rolled the window down a good halfway now. I keep reaching for the pen to sign it, and he keeps doing some song and dance. And I keep reaching for the pen, and finally I just went, "Oh, please, come on." It's the first hot day of the year. It was June 1st. And I reached for the pen the last time. He jerks the ticket book away from me, instructs the other officer who's shown up on scene really quickly, by the way, from a whole nother department, another town, little itty bitty towns here. And he instructs him to breach my back seat, break in my car, and start reaching for, I guess, my seatbelt. He starts reaching for my chest, so I push his hand away. And at that time, I won't go into all what I thought maybe they weren't police officers, because it just gets really weird. And I rolled the front window up, freaked out. And the first officer breaks the window in my eyes, nose, mouth, and chest. Everything just went silent in my head. And I just went, "What just happened here? What just happened here?" And the whole time I'm saying, "Am I being detained? Am I under arrest?" No, I don't have to answer those questions. Write me the ticket. You said you pulled me over because I was swerving. Possibly. I have a big car. Even though you didn't see it, give me the ticket. Let's get on with our lives. And they busted in my car on my side and wouldn't tell me anything. One officer wouldn't identify himself. And I hear he's the chief of the police department. He wouldn't give me name and badge number. And I kept begging, what am I under arrest for? I would like a code, a statute, or something, and suspicion isn't good enough, officer. I'm sorry, that isn't. Well, I must have really made them mad because they sent me to the ER and county jail for 4.5 months, sir.
Jeez.
And I've never been on that side of the bars before. No due process. I wish I could tell you I was eating babies alive in the car and they had to get in that urgently. It was like that. I wish I could tell you there was more to that story, but there isn't. They found nothing in my car. I mean, they searched it. They put me in a police car bleeding, and I watched them tear my car apart on the inside and my purse.
Wow.
I don't know.
That's terrible. There's not much I can offer as far as help right now because I got to wrap up in a few minutes. I've gone a little bit over and I'm glad I was able to, but I will have more time on the Saturday show. And considering this is like the 4th or 5th show without a tech issue, so we'll be live on Saturday. You can call earlier in the show and we can spend a little more time on it. I'm sorry to hear that you got hurt. 4.5 months. If there's someone who should be filing a claim for damages against these cops, it's certainly you. We could talk about that. But have you gone to court on this?
Thank you.
Sure. Have you gone to court on this at all?
Well, now, see, when I was in there all this time, they kept pushing court dates up, and I do not know the court system. I don't know that procedure. I don't know how that works. I'm a retired realtor. I know contract law, contract composition, and agency law. And that was my arena, and that's my little nook. So I don't really know what was going on in that courtroom, but it didn't seem like anything was correct. They still haven't done discovery. Come to find out, I went down and talked to an attorney's secretary because I cannot afford an attorney. I'm on SS. And I picked the wrong year to retire and the wrong state. That is for sure.
You picked to retire in Oklahoma?
Well, I'm Choctaw Indian, and we do get some perks here, but we have to live here. And boy, I made a mistake. I made a mistake. I can't help but think that this is for a purpose. I'm certainly hoping so. Because this is just the most ridiculous injustice I've ever seen, and it happened to me.
That's pretty bad.
I'll admit,
I'm sorry. I've had them threaten to baton my window, but they never actually did that. I've even had a guy named Han threatened to set my car on fire. They actually went and took a step and had the fire department there. That's why the judge was saying, what the hell was the fire department doing there? Because he was reading it. Yeah. And I said, because these animals were going to set my car on fire just to do a traffic stop. Yes. They're going to set my car on fire. These people are animals.
Yes.
So
exactly. I likened it to jackals with a tied up goat, and I was the goat.
Yeah. This is just this. All right. We'll do call. We'll get you on the first caller for the Saturday show, and we can get into this more. Okay.
Wonderful. And what time is that? And is it East Coast?
You see, that's always so disheartening. It's 2 p.m. 2 p.m. Mountain Standard Time, so it might be 3 o'clock Central. No.
Okay. 3 o'clock Central on your channel. All righty.
Yep.
It's a date, sir. Thank you so much.
You're welcome, Linda. Appreciate it. And we'll talk to you Saturday.
Thank you.
That is horrible. I would imagine, and I'm not blaming the victim, not blaming Linda. But there were some buzzwords in there. We don't do any of this UCC stuff. And after the initial identification, we're a broken record. Actually, you shouldn't be a broken record. I would say you keep your mouth shut. After the initial on advice of counsel. I am not answering questions. End of discussion, right? Nothing. You say nothing to these people. You don't say, am I being detained? You say nothing. You just wait until they give you the ticket or they give you the okay so that you can get the hell out of there. You say nothing after saying you're not answering questions. Nothing. And I have to just take a minute. I ran out of time. But hey, it's better to get the calls. We had some really good calls, covered some good ground today. I did have to bring out, interesting that the Court of Appeals, Trump's longtime lender, Deutsche Bank, must turn over a broad range of financial records to Congress, a federal court's appeal ruled yesterday. The ruling blocks another effort by the president to keep his finances private, though he's likely to appeal, of course, keep it tied up. The U.S. Court of Appeals for the Second Circuit ruled 3-2 that public interest favored disclosure of the records regarding Trump's private business, as well as those of his family members and related entities. House committees' interest in pursuing their constitutional legislative function is a far more significant public interest than whatever public interest adheres in avoiding the risk of a chief executive's distraction arising from disclosure of documents reflecting his private financial transactions. So that it probably seemed pretty damn likely. Now, there are a lot of investigations. I don't have the time to get into this. But the reason why I'm mentioning this is because just a few days ago, now remember, no American banks would loan Donald Trump's business money because he never pays anybody back. He bitches about NATO not paying their fair share, and yet he has left millions of unpaid bills just on his campaigns, his rallies. He doesn't pay anybody. He owes hundreds and hundreds of millions of dollars, and he's complaining they're not paying their fair share. This is a guy who has, for 50 years or 40 years, like his father, didn't pay vendors. So Deutsche Bank, and I know that we have Brett Kavanaugh on the Supreme Court because Justice Kennedy retired and Justice Kennedy's son worked for Deutsche Bank. Well, one of the bankers who oversaw and handled the loans to the Trump business, now he is under investigation. He is a target. The FBI and the state authorities in Manhattan are investigating criminally Deutsche Bank. Well, they're part of the Trump investigations, and so one source who has direct knowledge of the FBI's investigation into Deutsche Bank said that federal investigators have asked about Bowers. Bowers was the Thomas Bowers, who was who oversaw the Deutsche Bank loans for Donald Trump. Killed himself a few days ago. And this is knowing we have he killed himself like Epstein killed himself. All right. That the federal investigators have asked about Bowers and documents he might have. Another source who has knowledge of Deutsche Bank's internal structure said Bowers would have been the gatekeeper for financial documents for the bank's wealthiest customers, and dead at 55. He lived, dead at 55. So, maybe he's sharing a beach with Epstein. I don't know. But what we do know is the reports are that he's dead, and he was part of the investigation into the Trump Deutsche Bank finances. I know politicians are all corrupt, but this is off the charts corrupt. I mean, this is a guy that's got a scandal every day coming out. I know, Orange Man bad. Whatever. Hopefully this is not over. And that these investigations continue and some amount of accountability. We can't say there's been no accountability because his own lawyer, Michael Cohen, is sitting in prison. Paul Manafort is sitting in prison. Roger Stone will be sitting in prison. So it's not as if at least the useful tools for the elite are not ever held accountable. This is so it's good. It's good it's good to see this. It's good to see this. We'll see what happens. I wonder how many other people that are connected to Trump's finances and connected to the Trump crime family, how many of them are going to wind up dead? I don't know. Maybe they're not dead. We don't know. Maybe there actually will be people that will suffer death. We don't know. But I figured I had to get that little more reporting regarding these elite criminals. Yeah, Trump, a criminal for his entire life, and he gets a platform, the biggest platform to commit crimes that the world's ever seen. So, someone's saying I'm an a-hole and support the deep state. Sure, I do. Yeah. I'm a big deep state supporter. All right, whatever. Just looking at the facts. Looking at elite, high-level government people doing whatever they want. The rules do not apply. They don't apply. So, whatever. I'm not even gonna justify that any further. But I appreciate everyone tuning into the big show today. If you want to help support the show, again, Chris in California, really appreciate the support. If you'd also like to support the show, markstevens.cells.com and markstevens.net. I will be live on the Saturday show, and that is at 2:00. Is it 2:00 Mountain Standard Time right here on the No State Project on YouTube. So till then, salud.